Next we have to look at something called as consideration. So any contract, consideration is very important, because it is the one which form the basis of a sound contract. So A sells goods to B, not for just for free. In return he expects something from B. That is what is called as consideration. No consideration, no contract. There is no consideration, then there can be no contract at all. Now what are the rules, or the ground rules or the thumb rules regarding consideration? Consideration must move at the desire of the promisor, that is the person who has volunteered to sell the goods. The consideration may move either from the promisee or any other person. So it can be moved either from the other side or from the promisor. Consideration need not be adequate, not just the consideration which A and B are going to exchange will be for the total goods. It need not be adequate. It can be something which is related to the goods. Consideration must be real and competent. It should be real. It is not something which cannot be measured. Consideration must be legal. Suppose A sells goods to B, B has to pay money only. He cannot say, I am going to give you something, a lottery chit for you in exchange for the goods. So because selling of lotteries is illegal, so it has to be legal. Consideration may be present, past or future. Sometimes the consideration can be for the present transaction or future transaction or for the past transaction. Unlawful consideration and object. Suppose there is unlawful consideration, is it considered legally? There are certain instances where the consideration and object agreement are unlawful, thereby making it unenforceable. So as per section 23 of the Indian Contract Act stipulates that an illegal agreement as one where the consideration or object of which is forbidden by law, or defeats the provision of any law, or is fraudulent, or involves injury to the person or property of another, the court regards as immoral or opposed to public policy. So which means if the consideration is going to be impracticable or something unlawful, then it is not considered eyes of the law, and the particular transaction is not considered as a legal transaction. Like for example, suppose you say, I am going to do some contract between A and B where A is going to sell the goods, and B in turn as part of consideration is not going to pay money, but going to do something illegal activities like narcotic. He is going to give one consume narcotic drugs exchange. It is not a lawful consideration, because the contraband goods or narcotic goods are not lawfully allowed to be traded in any country, and especially in India. So it is a unlawful or illegal consideration. Agreements declared void. Void means what? It is not first a contract at all. That is what is coming with void. Void means null and zero. There is no existence at all. The Act declares certain agreements to be void. Which are them? Agreements against public policy, that is, which are going to affect the public at large, are called void agreements. Agreement restraint of trade, like for example, people can't enter into agreement where people say you should not do a particular transaction, or you should not deal with a marketing of certain goods, or you should not do this business. So agreement restraint of trade. Restraint of legal proceedings, that is, A and B agree saying that they should not enforce legal proceedings on each other. In case there is a breach of contract, I should not go to the court to take breach of contract or for seeking for damages. Uncertain or ambiguous agreements. There is agreement between two people, but it is not very certain or very clear. Like A and B enter into a contract, but they do not show what is the type of goods they are going to handle, what is the place of the destination where the goods are to be delivered, and what is the consideration, or it's not very clear as to what are the various terms which be agreed between both of them. This is called unambiguous or uncertain agreements. Then wagering agreements. Wagering agreements means which cannot be enforced by any court of law. That is called wagering contracts or wagering agreements. Then contingent contracts. Contingent means something, an event has to happen. A contract will be enforced on the condition that some event will happen or will not happen. That is what is called as contingent contract. A contingent contract is a contract to do or not to do something if some event collateral to the contract does or does not happen. It can be positive or negative. Now, what are the essential characteristics of a contingent contract? The performance of the contingent contract are: the event must be uncertain, event must be collateral, that is incidental to the main contract. Now, the Act also stipulates what are the various types of contingent contracts. Contingent contracts to do or not to do anything if the event becomes impossible or such contract becomes void. Contingent contract to do or not to do anything if the uncertain event becomes impossible or not before the particular date. A contingent agreement to do or not to do anything if an impossible event happens or void. So these are some of the stipulations provided under the Indian Contract Act with respect to contingent contracts, but these are only some sort of guidelines. There can be other contingent contracts as well. So it all depends upon the course of business or during the course of business transactions which we come across in the day-to-day activities. Now quasi contracts. Quasi contracts means they are contracts but not a real contract. That's what it's called, quasi contracts. Certain relations resembling those stated by contracts. Now what does mean quasi contracts? Quasi contracts are so called because the obligations associated with transactions are neither referred tortuous nor contractual but still recognized as enforceable like contracts. The same is called as quasi contracts. Now these are some of the examples where mentioned that what are some of the quasi contracts. Claim for necessaries supplied to a person incapable of contracting on his account, that is, he is not of sound mind or is a minor. Reimbursement to a person paying money due by another in payment of which he is interested. Obligation of a person enjoying benefits of non-gratuitous act. Non-gratuitous act means he is not expecting anything in return, but in spite of it he doesn't act. Responsibility of finder of goods. Goods has been lost and a person takes the interest in locating the goods. So in such cases he becomes a quasi contract. The liability of a person to whom money is paid or thing delivered by mistake or under coercion, which means like by mistake the book has or article has been delivered or by force goods has been delivered. So in such cases the quasi contracts will come into play. Now let us look at what is meant by contra merit. It means the contract is considered unenforceable, or one party abandons or refuses to perform the contract, or the contract is divisible, or an individual contract incompletely but badly performed is what is called as contra merit.